Okay, it's now time to move into the subject of estate planning. And what I would like to do is there will be about five, probably about five or six areas that I'll be covering in this on the subject of estate planning, and I'll explain those in just a moment. But what I would like to do is first of all discuss the why we have estate planning, those professionals that are involved with estate planning, and this applies regardless of the size of the estate. There are obviously more complex documents and more advanced types of consulting that takes place when you have more complex estates, and we'll discuss that as well. And from this launching pad or this foundation, we will then move into the family office. As we start to wrap up this semester, we'll talk about the family office, the structure of the family office, and then, of course, looking at it from an international standpoint and see how estate planning would be applied in wealth management when you talk about cross-border type issues. But just to give you an idea of what we're covering here this week, is I want to discuss just the administration of an estate. Once we have that down, you need to be sure that you understand the terminology that's used, because many of these terms will be used as we talk with the more advanced estates. And so we'll get the fundamentals down here, and that would include the probate process. We'll talk about probate. We'll talk about the administration of an estate when there's a will. We'll talk about probate avoidance techniques, certain ways that estates can be structured to completely bypass probate. Then we'll move into a discussion of trusts. We'll talk about gifts briefly, talk about the subject of gifts, and finally wrap up with those important documents that everyone needs to have in place regardless of the size of their estate. Everyone needs to kind of consider these basic documents as just fundamental estate planning steps that need to be taken. So with that, I'll go ahead and jump into this, and we'll see where we go. Thanks. Okay, so I thought I would start with this illustration of a family office, which kind of gives you an idea of just how broad or how deep estate planning can be, with a lot of different professional services needed in order to run the family offices, the businesses, and plan for generational wealth distributions, whether it's to charity, to children, or other objectives. And so this illustrates kind of the nutshell of that. You have wealth management, of course, with the investment policy statement. Different assets have to be allocated towards different types of investments with certain time frames, certain levels of risk and return assumptions that would need to go into planning for these, short, mid, and long-term objectives of the family. You may have, obviously, you have tax planning that goes along with this, because a number of different areas of taxation, whether it's the parents, the children, the trusts, taxation of the businesses, taxation issues relative to gifts that may be made. So a lot of tax planning. So you need experts in those areas as well. There may be trustees that are running different types of trusts that are established, and we're going to be discussing trusts in this section just to give you the most fundamental definitions of these trusts and their function in estates. Family governance. This is where, of course, you may have very large family operations where you have multi-million dollars. We're talking about 30, 50, $80 million estates. And so when you get into those types of estates, there's a huge need for as much structure as you can have. And that includes a family mission statement, a family charter or constitution, you may say, a family values statement where the family defines who they are, or who we may say who we are as a family, what we would like to accomplish with, what our values are. This is how we would like our wealth to be used, both not only internally but externally, whether it's environmental, social causes, healthcare causes, maybe the arts. As you may be aware, there are a lot of families that fund these types of needs throughout the world. And so a lot of that comes through these family foundations where they set that up. And it can also go, these types of family offices can include training or education for those who were born into these families, to give them throughout a period of years, educate them on who the family is and what the family stands for, so that when the younger generations move into hopefully management roles, maybe with the family, they'll at least understand, those core principles that kind of define the family. and they could carry those forward. And so some of these larger family offices actually have training for the younger children and grandchildren who are kind of coming into the fold there. So let's get started by taking a look at the roadmap here. I have the estate planning process. We'll discuss the team, and then we'll move on to discuss probate, ways to avoid probate, and also the probate process, the estate administration process. And I'll use a typical case in Carolina. I'll just use the Carolina rules for administering an estate. Then we'll talk about the important documents that would be needed just while you're living, regardless of the size of the estate, documents that everyone should consider. And in particular, we're going to be looking at wills and trusts and gifts as the planning tools. So important documents, this is where we're talking about the living will, the durable power of attorney for healthcare, the financial power of attorney, and revocable trust that can be set up for incapacity planning. So this section, we're really talking about incapacity planning and how you would like things to be managed should something happen during your lifetime that affects your health. We will be drilling deeper, though, into the wills and trusts and the gift area to kind of explain how those documents work within estate planning. So let's go ahead and move on to the next slide. Now, while I'll be providing slides that have kind of a breakdown or bulleted list of items, I'm not going to spend time walking through every one of these. You can read this yourself. It's not difficult to understand. Should there be terms that need to be explained, for example, executor, codicil, terms like that, I'll be focusing on those and discussing that. But generally speaking, I'll have a discussion about the slide, and you can then be left to look at the slide or review the slide on your own. So in terms of the estate planning process, I consider estate planning to be it's not just planning for death and what happens after death. It's basically a process for accumulating wealth, protecting that wealth, preserving that wealth, and then sending that wealth on after your death to other parties, whether it's a charity or children or some other cause. So it's actually taking place. Estate planning is really a process that is ongoing throughout one's life. Okay, so it starts, at a point where someone says, I have assets. I need to sit down with someone and talk about those core documents that I need about what happens if I were to have an auto accident and I have a spouse and children, some minors. What about my own health? Who's going to make those decisions? So that's the most fundamental area that needs to be looked at. But of course, then you have those assets. And as we grow assets and have more complex situations like a business that you may own, then we need to be looking at things like buy-sell agreements or estate equitable distribution of an estate where you have a business with hard assets. And children of the marriage may have different levels of interest in the business. Some may be involved, some not. So it gets more complex as you go along. So let's just look at this list briefly. Providing for the family, of course. Should you die, life insurance comes to play here. Do we need term? We talked about term versus whole life. On the estate planning side, it may be that more permanent insurance may come into play. For a lot of people, that term insurance may be needed early on. So this is kind of where we look at those things. What are the goals of the family? So there's a short-term goal, take care of the risks, ensure that the children are cared for and protected or supported until they can be independent. Controlling the asset disposition, you may have specific goals for your assets when you pass away, whether you pass or if something happened 20 years from now or 60 years from now. You may have your thoughts on how you would like your assets to be applied. So that planning takes place as well. Obviously, along the way, we're going to try to do this as efficiently as possible. This is where the tax minimization comes into play. And then finally, we have protecting beneficiaries. Not only protecting beneficiaries, but also protecting you. Number one, from creditors. That would be an important, having asset protection along the way. Definitely when you have certain professions as well. There could be potential lawsuits where people may want to treat may be coming after assets, and having the asset protection for your existing estate, and then also for the children, protecting them from creditors as well as protecting them from themselves. Finding ways to be sure that if they're coming into a lot of money, that the money's not just wasted by the child who's maybe not mature enough yet to handle that money. So that all comes into play. What are the goals of the estate plan? Of course, as also the values-based estate planning takes a larger role as the estates grow and grow and grow, where you're really trying to preserve for generations, multiple generations of heirs. There are risks involved along the way. One is in doing nothing. This is where the laws of intestacy and state laws on intestate succession come into play. And so if nothing is done, if you were to pass away without a will, then you would look to the state statutes to determine how your property would be distributed. And so this is where, of course, you've heard attorneys probably say this on television. Do you want the state to decide where your money goes or where your assets go? Well, if you die intestate, then the state statutes will control. And so on the right-hand side of the slide, you see the common risks. Other risks have to do with family, unfortunately, disputes that take place. And it's not uncommon that families will have disputes when someone passes away and there's disagreement about what the parent intended for their assets in terms of claims to the property. And so finally, we have the titling issues. And this is what we're going to look at when we look at the probate process. Titling is really important. For example, you have a title to your car, I would assume. Is it titled individually? Is it titled jointly? You may have other property that's owned jointly with someone else, could even be land. So we need to look at how that property would be distributed, and is it where you would want that property to go? And when I say you, we're putting your hat on as a professional. If you're in wealth management, you're looking at the client. Does the client have real estate? Does the client have other assets that have titles that we need to look at that may need to be retitled? Do we need to put some of these assets into a trust and retitle the property completely so that it's now trust property? And so that, we'll get into that as well. Okay, let's go ahead and move on. Okay, this slide just basically covers the estate planning team. And again, self-explanatory. I'll leave it with you to study further, but you have obviously the client, where the financial planner or the team would actually be meeting typically it's meeting one-on-one with the planner first, and the planner then helps the client put together a team, or the client, in a lot of cases, will have their own attorneys and CPAs already in place, and it's a matter of just coordinating the activities of the team. So we have the client and the family looking at their goals, their objectives, then looking at the estate attorney that would be involved, and this is where general practitioners can do a lot of work in terms of straight wills and trusts and those documents that are needed that I say that are the fundamental documents for incapacity planning. They can do that type of work. But when you get deeper into these structuring an estate plan that may involve more complex trusts, this is where I would think you'd be going to an estate attorney, an attorney that actually works with estate planning specifically and is very familiar with trusts as well as the tax implications associated with trusts and gifts and moving of property, titling of property, those types of things. So there are estate planning attorneys. There are also tax attorneys who it could be tax attorneys / estate attorneys. They almost a given they have to have knowledge of tax law in order to be an estate planning attorney. So there's that role. Then you have the CPA. CPA, naturally, again, just about every transaction is going to involve some type of tax implication. Trusts have certain taxation rules. Gifting, there are gift tax rules, obviously income tax rules. When property moves to the next generation, there are tax effects that could result from that. And so planning to minimize taxes, having a CPA who understands estate tax law is also important. Naturally, the financial advisor, that would be, in a lot of cases, the person who's meeting with the family. Financial advisor, financial planner, that's where they look at the client picture. They may be involved also with respect to the wealth management piece, handling of the assets. In fact, it states your asset management, investment planning, beneficiary coordination, trying to set up. But of course, this is also where the attorney comes into play, looking at beneficiaries and the CPA, because beneficiaries have certain rules under the IRS law that they have to take assets that are coming out of retirement plans at different time frames potentially. And so all three of those parties, as you can see, there's a lot of coordination that has to take place here. Insurance may come into play, especially if you have an estate where you have a potential for liquidity needs. say a closely held business. We discussed this earlier in the semester. Closely held business where you have one child who wants to take control of the business and own the business. Another child may have nothing to do with the business, but you want to equalize the estate or have some equitable distribution of your assets to all children. And so providing liquidity can be important there for a child who may not be receiving stock in that business. Trustees, anytime there's a trust involved, there's going to be a trustee that comes into play at some point when the trust comes to life, whether it's during your lifetime, where you have irrevocable life insurance, irrevocable trusts, living trust, revocable living trust. There's a trustee involved there because you have trust assets and someone has to manage those assets on behalf of the trust and the beneficiaries. And then, of course, you have the executor, which is the probate. Now, when we get into probate, administering an estate, the executor has a lot of work to do in a lot of cases, and so they have a very important role. They are a fiduciary. There's a very high standard of conduct and integrity that goes along with being a fiduciary and an executor of an estate. And then, of course, the last one here, and I think I'm in the way of it here with my video here, but it's the appraiser. Anytime there's an estate that has to be settled, the property needs to be valued. And so bringing in an appraiser when someone passes away and conducting an appraisal is very important. And we'll be getting into that. So, all right, let's move on. Okay, moving to section 2 now. We've discussed the roles of the planners. And now let's talk about the assets that will be subject to probate and then some basic ways that probate can be avoided. First, probate. What does that mean? Well, it states here it's essential to validate your will to ensure that your provisions of your will are being carried out. And so basically it's where a court, typically the court in the county where the deceased passed away or resided, where they lived, that county court, a probate process would take place where the will is introduced to the court and the clerk of court that will look at the will. They will validate that will. We'll talk about what that means. And once that happens, then the estate needs to be administered. And there's a step-by-step process I'm going to walk through here. But let's look at the other bullet points here. Other advantages of probate, you might say. Putting creditors at notice. Okay, if a person passes away, there are the known creditors, and then there are creditors that the executor and the family may have no idea are even out there. And so there's a requirement to publish a statement letting people know that this person has passed away. When we used to have newspapers, that was published in the newspapers, the notice to creditors. And so that's a step that has to be taken as well. The advantage there is, of course, is the creditors are barred from then later coming back at a later time and challenging the will or saying that the distribution should not have occurred to the children because the estate owed them money that was never paid. It's basically putting the world on notice. This person has passed away. Bring all of your invoices and let's settle things. And so there's a time frame for that we'll get into. It says it's also good to prevent later challenges by creditors. No, of course, I've covered that. Typically, the following methods can be used to transfer property and avoid probate. Okay, here are some basic tools that are used to avoid probate. And why are we trying to avoid probate? Well, probably two reasons I can think of right away. One is the cost of probate. You know, it costs to administer an estate, and the more assets you have flowing through that estate, the more time consumption there may be in terms of the parties needed to administer and ultimately settle that estate. And so there's a cost factor. Also, there is a privacy component here. Probate is a public process. When you go to the court and open up an estate, that becomes public record, including the inventory. And we'll touch on that in just a few moments. But there's an inventory that's made, and this is a public process, and a lot of people prefer to keep their matters private. Third is the efficient, I shouldn't say efficient, maybe it's a faster way to get the assets into the hands of the heirs without having to be tied up for a year, 2 years. Very, very common that estates could be open for more than a year, up to 2 years, 3 years. And of course, when you get to the larger estates, they may be open for more years than that. So, but generally speaking, in fact, I was involved 2 years ago now with an estate that was, we opened it up in September, and it was probably 2 years and a little bit more before we were able to close that estate. And now it had a couple of it had some trusts involved and some arrangements that had to be established in order for the property to get to the proper parties after the death. But it did take some time, and it was not a complex estate. It was just there was just time involved in collecting all of the assets, having assets sold, selling homes, liquidating portfolios, and moving that property into the estate. So a lot of moving parts can keep those estates open for a while. So let's look at those ways now where we can bypass that and have that property move on to the heirs. Okay, number one, joint ownership. If I were to have an ownership interest in, let's just say, an automobile with you, we jointly own the property, Kevin Huff and MBA students, joint tenants with full rights of survivorship, JTWROS. That's what that means, joint tenants with rights of survivorship. You may have that on a bank statement with someone right now. Okay, what does that mean? Well, it means that if I were to pass away, then by operation of law, meaning state law has already defined that property is yours. Okay, so if we have jointly held property with rights of survivorship, and that's a specific term under the state law, then it happened. Nothing's really required for that property to be yours. It is yours. Now, there may be a step needed for you to make it yours in terms of going to the, you would need to take the death certificate and go to the whatever I said, a car. You'd have to prove to the DMV, I guess, that this person had passed away to have that title of the automobile reissued in your name alone. So there's the titling issue that needs to be cleaned up to take my name off of it as a joint owner. But in terms of the eyes of the law and the state law, that car basically becomes yours the day that I pass away. Okay. Other assets, there may be a longer delay before that person becomes entitled to that property. Say a distribution of some estate assets through the will. Okay. So we have payable on death accounts and transfer on death accounts. These are terms. Different states have different rules regarding POD and TOD accounts. But just to put it briefly, payable on death means a banking account, checking account, savings account. I could have an account that says Kevin Huff, payable on death to my daughter, Jennifer. Okay, POD, Jennifer. And Jennifer doesn't have any access to that account. It's my account. I own that account. And as long as I'm living, she has no rights to that money. But if I were to pass away, then again, the death certificate is issued to the bank, and the bank recognizes I said pay on death to this person. And so they actually pay that person the savings account or the checking account, the money that was in that account. Transfer on death really is similar. It's just that it involves securities, not bank accounts like savings and checking. It may involve stocks and bonds held by an investment firm. And so just a different type of account, but the effect is the same. That person has no right to access that account and take that money without, until you passed away. And of course, I could change the account. I could drop their name and just change it to someone else's name. I have full control over that account. Gifts during lifetime, obviously, if I were to give you or my daughter, my neighbor, give a lawnmower to my neighbor, that's a gift that I'm making. And that lawnmower may have been worth something, a nice Kubota, zero-turn lawnmower, $5,000 mower. Well, Kubota is probably more expensive than that. But I'm giving a gift away that had value. And so if I'm parting ways with that and I have no strings attached where I can't reel that back in like you're reeling a fish back in, as long as there are no strings attached, then that's considered a completed gift and it belongs to that other party. And when that's the case, it's no longer in your estate. And no longer probated through your estate. Let's see what else we have here. Okay, trusts. We're going to get into trust in a deeper way, but trusts are a way by making gifts to the trust or putting property in a trust, it can bypass probate. And there's a very common way that people are able to retain control over their property and not make that completed gift, but have control over the property, even liquidate the trust and just take the property back in. Of course, they may physically always possess the property, but they can have the property named or retitled into the trust while they're living. And if they were to pass away, the trustee simply takes that property and sends it to the beneficiaries. Okay, so that's one way during your lifetime to set up a trust, make gifts to the trust, place property in that trust, And if you were to pass away, the property bypasses trust. Life insurance, naturally, if you have a life insurance contract and you've named the beneficiary, if I have a $500,000 policy and I name my two daughters as beneficiaries of that policy, then at my death, they simply file a claim with the insurance company. That does not flow through probate to be probated by the court. That goes directly to them. It's a contract that the insurance company has to fulfill by paying them directly. They just cut the check directly to my to whoever I have listed as the beneficiary. Let's see what else we have here. Okay. Your IRAs and 401ks. Remember that those plans that we set up to grow our assets will be asked when we set up those accounts at your place of business, or if you were to set up an IRA with an investment firm, they'll ask you for the name of a beneficiary. Okay. And typically you'd put that name down, the name of the person who'd like to have that property. And if you fail to do so, if that remains blank, then there will be a default setting by the document that's used in that account, that IRA or that 401k plan. There'll be language in that document that says if there's no beneficiary named, then the default beneficiary is going to be your estate. So it could end up as being part of your estate and would be probated in that case. But in most cases, people will have beneficiaries named, and that will go outside of probate directly to those beneficiaries, very much like the life insurance policy would do. Okay, just as I was leaving that page, I saw something at the life insurance line. I think it says, if the deceased did not own the contract was here. I just deleted that. That statement had to do with estate taxation in your gross estate. Briefly stated, it's this. Anything that you have control of at your date of death, control over, I can't think of an exception right now, would be included in your gross estate because you had control up to your date of death in that piece of property. And so it is valued for estate tax purposes as being part of your estate. Life insurance, if you have control of that life insurance policy up until your date of death, then that would also be included in your estate. So you may have if your estate is a taxable estate, and we're talking about a very high number here, the exemption is $15 million per individual now. So we're talking about very large estates. The reason I took that out, though, at this point, is that we're talking about probate right now. And I don't want to confuse you. When we're talking about probate, the probate process, the life insurance, whether you own it or don't own it, it's going to bypass probate because there are named beneficiaries, and the life insurance company pays when the beneficiary sends them a death certificate that says, this person passed away and I'm a beneficiary. They do the paperwork and the beneficiary's paid. With respect to the gross estate, however, that's where you look into this ownership issue of, well, did the person still have strings attached? And should we include that value when it comes to taxation? So I wanted to get that off of that slide just so that you would not be confused. Okay, so life insurance proceeds payable to beneficiaries, those do not go through the probate process. So that's a true statement. I just had some language beyond that seemed to make things muddy, which had to do with the state taxes, and I wanted to get that off the slide. Okay, let's move forward. Okay, so we've discussed those items that kind of bypass the will, which bypass probate, and we go directly to the recipient or the heirs, the beneficiaries. The other property will go through probate, though. The property that remains, your equipment, your tools, your furniture, your automobiles, those types of things would normally go through the probate process. There is one item, and we'll talk about that process in just a moment. There's maybe 14 or 15 steps to that. But let me first talk about this public process or this public proceeding. When it comes to probate and estate, privacy can be a concern of some people, and that has to do with when these documents are filed with the clerk of court, an inventory is required within, I think it's 90 days in North Carolina. There is an inventory that has to be put together. And this is where the administrator or the executor, as I will call them, of the estate will need to go through all items this person owned. And I mean down to the jewelry boxes in the bedrooms and the furniture in the basement and the lawn equipment and everything this person owns, stocks, bonds, bank accounts, all of that property will need to be listed for the court and filed with the court. And there's an actual inventory, like a balance sheet, where all of this information is recorded and submitted to the court and filed with the court. And so that is, unfortunately, it is a public proceeding. And so it states here what is subject to the public, where an individual can just walk right off the street and look at an estate file with that personal information in there. The will itself, the contents, the will in the language of the will, to whom the property is going to be distributed, all of that in that will, so people will know where the property will be going, how this person wanted that property to be distributed. That inventory I just mentioned, beneficiaries' names of the estate, those who will be inheriting that property. Okay, I moved myself out of the way here, and there was a typo. I paused the video and I corrected this. That should have said creditor names, or should say creditor names. I had debtor names there, so sometimes when I review my material, I make those mistakes. So anyway, I caught that just as I was reading through this, and so that should be creditors' names. The decedent owes debts to creditors, owes money to creditors, and so they're entitled to approach the court and say how much is owed and have that paid out of the estate. And then finally, disputes filed. If there could be disputes that are ongoing throughout the estate, whether they're related to the business the individual owned or family members, and those disputes, that type of information is filed as well and is public record. Okay, let's move on. Okay, so the next two slides basically covered in a little bit more detail those items I've already mentioned. POD accounts, TOD accounts, avoiding probate, the titling, the joint tenants with rights of survivorship. It explains that as well. Let me move on now to a type of property that has to do with titling, but it does go through probate process. Joint tenants, we said, with rights of survivorship passes by operation of law. You need to memorize that term, operation of law, and does not go through the estate. However, you may own an interest in a piece of property with someone as a tenant in common. And basically what it means is there are two or more people who own an interest in a piece of property. You have the right under the tenants in common arrangement to, in your will, assign that right to someone else. Okay, so it doesn't pass by operation of law automatically at your death. It does flow through your estate, and you can leave whatever piece of property that is to a third party. And so that would be one type of titling that would go through probate for sure. Okay. Now, we're going to move into the estate administration process. I'll hopefully spend very little time just kind of summarizing, but please read each bullet on this list because it's a very methodical process, and I think it will give you a good picture of how an estate runs from start to finish if you do just follow reading each number and each bullet under those numbers. So first of all, we have the death, we have the death certificate. Second, there's responsibility of those parties, who were aware of the death, family members typically, to take that death certificate and go and naturally see an attorney. I would never recommend not to use an attorney and try to do it yourself unless it's a very small estate, in which case you may have a court administrator, the clerk of court, may be happy to kind of work with you and help you along. I'm saying you because we have to make this kind of personal here. Assuming let's just assume in this run through that you're the executor. And so you would meet with the clerk of court, and depending on the size of the estate, smaller estates can be administered much more efficiently without the need of an attorney. But generally speaking, with average to large estates, having an attorney involved is very important because they will always be aware of dates, filing deadlines, documents, forms, that unless you're in the business of being, an estate administration professional, that you may miss some things, and it could be costly. Okay, or time consuming. It may delay things if you don't get the forms filed correctly. So gathering the documents, seeing that attorney, pulling up the original wills, and codicil. I'll go ahead and say what that is briefly, but I think there's a separate slide on it. A codicil basically is a change to a will. You may have created a will 10 years ago, and then 5 years ago decided to make a change. You, instead of wanting Sam to have $20,000 of your assets, you want Sam to have $50,000, and so you create a codicil to the will. Again, a codicil is going to come up later. I'll explain how you do that. There are steps to do that, and there are incorrect ways to do that, which means that Sam gets nothing except $20,000 because that codicil wasn't properly executed. So we'll talk about that. So you pull together those documents and gather a list, kind of a rough cut, you might say, of the assets and liabilities, the heirs to the property. Sit down with the attorney and kind of discuss with them how to go about opening that estate. And with the attorney's guidance, and I've jumped ahead, let me find my place here. The estate would be opened. The attorney typically goes over and files with the clerk of court certain documents. You'd need to sign. If you're going to be the executor of the estate, you'd make certain representations. The attorney would walk over and present that, and then call you on the phone and tell you that the estate's now been set up. You're now listed as the executor of the estate. And so that's the first step. Now, with that, though, of course, the attorney is going to be taking the will to the court and having it filed with the court as well. That will has to be validated. It has to be filed with the court and approved or recognized as being a real document, a real will. Based on certain information, the clerk of court will authorize that to be the valid will. And so what it's going to require is that the will is presented along with affidavits of witnesses. Now, there are wills called self-proving wills, which means they come with those affidavits already attached. Now, this is how that would happen. Kevin Huff, let's just say 10 years ago, I go to my bank and I take my will in. I need two people. I would tell the bank, I'm going to sign this will before, in your office, and I need two witnesses to witness me signing this will. And so they bring in two people who do not know me, are disinterested parties. They have no stake in the game. They're not going to be receiving anything under the will. So they would qualify as witnesses. And so I would sign it. They would watch me sign that will. And then they would complete an affidavit which says, we witnessed Kevin signing this will on this date, and that their signatures would be notarized as well. Well, now you have three documents. You have the will, and you have two affidavits from two witnesses. And so those three documents combined would be what a clerk of court would want to see in order to say, okay, we have the will and we have two witnesses that have validated or verified that they witnessed this person signing the will. If those affidavits do not exist, then you may have an issue or a time delay in getting the witnesses. If you don't have an affidavit from them, you may just have witnesses' signatures on the will itself. And so that would not be enough. You would need to locate those witnesses and have them testify that they, in fact, witnessed that person signing the will. Okay, and that could be a time-consuming thing. So it's much more effective, much more efficient to have them at the time that that will is signed, fill out those affidavits and sign those themselves, and those just go with the will. Okay, before moving on, just a quick point about what happens then at the court once that will is filed with the affidavits from two witnesses or the witnesses themselves testifying, which again, they could be remote. Zoom calls are possible. It's possible to have a Zoom call with the clerk of court so that they can say, yes, that's my signature, and yes, that was that person who signed the will in front of me. So, but once that happens, letters testamentary are filed. That's a document. It's a North Carolina form that's filed that says letters testamentary. This is where you, if you're the executor, would be installed as the executor of the estate. And there would be some fees that would need to be paid, and you would then set about to run the business of the estate. Let's talk about what that is. Okay, let's see. Okay, I'm a little backtracking here. The clerk of court reviews the will. They validate the will. That's all covered. Personal representative is qualified. That would be the executor. Okay, executor of the estate. It says if it's named in the valid will, it'd be the executor. If there's no will, there would be an administrator. That's the person here, an administrator. So that's when we have the intestate estate. If a person dies without a will, they still may own a lot of property that has to be probated in some manner, but it's called an estate administration. You're not probating a will at that point. You're administering an estate, okay? So that's where an administrator would be installed. And if you had a loved one who passed away and you were going to the court without a will, you'd go through the same process, but again, you would be named you would then be named an administrator of the estate. You would not be the executor. But we're going to keep the name executor because we have a will in this case, and we'll walk on through. Okay, so as stated before, you'll be a fiduciary. That means you have the highest level of standard of care imposed upon you as an executor. You're considered to be one who has the sole interest of the estate at heart, meaning that you will not have any self-serving, self-dealing in the estate, that you will administer it with the interest of the beneficiaries at heart. And so it's a very high standard that's placed on a person who's serving as executor. To wrap up this slide, we have the notice to creditors, which I mentioned briefly earlier, where you have to publish a notice in a circulation, typically a paper that's circulated in the county. If they are a creditor that you already know about, you need to notify them directly. But there are those unknown creditors that are out there, and you do that by publishing, I think, does it say 4 times? Once a week for 4 consecutive weeks. And once that happens, you start the clock and count 90 days. And so the creditors have 90 days to bring any claims that they may have against the estate. Otherwise, they're forever barred from raising a claim later. And that's one of the advantages of going ahead and probating an estate and taking care of these matters, is once the estate is closed, or once this 90-day period rolls through, then the beneficiaries no longer have to worry about creditors coming out and saying, wait a minute, that Sam owed me, $20,000, and having to try to rein in that money that was just distributed months before to the beneficiaries. Okay, working through the remainder of the steps here, you have an inventory that's filed with the court, which means all the way down to, again, the jewelry, clothing, furniture, land, real estate, other property, bank accounts. Just make the laundry list. And I mentioned I had helped settle an estate. I was the executor of an estate 2 years ago, and I was actually having to, take out the jewelry and inventory that, and go to an appraiser, and having a qualified appraiser issued a qualified appraisal report stating the value of the jewelry, because that had to all be submitted to the court as part of the inventory. Okay, paying this estate expenses and claims. Again, any debts of the estate are typically paid with all of the assets that are flowing into that estate. Some assets may have to be liquidated. You may have to liquidate a home. You may have to liquidate land, sell that land, hire a broker to hire a real estate firm to come and sell the property. And so all of you're coordinating all of those activities. You may need to clean up property and hire people to come in and repair and do other things to prepare property to be sold. And so the executor can have a huge role, and it can take literally months, if not years, to work through all of those steps to properly account for and ultimately distribute those assets. Now, tax is an area where I won't try to keep this concise. Let's just assume a person dies in July. That is a short tax year. A person did not make it all the way through the tax year. So you would have a tax return which covers the individual's income up until their date of death. Then, beyond their date of death, it becomes a fiduciary report. You file a separate type of tax return. It's not the 1040 anymore. It's the fiduciary tax form that has to be filed. The estate files the fiduciary return, okay? And this is where you have to have a cutoff point with assets up to the date of death. All income after that date of death, let's just say July, from the date of death forward, would be fiduciary estate income. And so a separate tax return is then filed by the estate with income, where there may have to be taxes that would have to be paid by the estate on that income. And then finally, when all assets are distributed out of the estate and the estate is closed, a final estate tax return would be filed. So you could have 3 separate returns: the decedent's final return, the fiduciary return that would be filed for the remainder of that year and all following years, no matter how long the estate stayed open. And then finally, the closing, which shows all assets. That final fiduciary return will show all the assets going out to the beneficiaries, and it'll zero out, and then there would be no more returns to be filed by the fiduciary estate. Okay, now once the all the debts have been paid, taxes have been paid, uh, all the work has been taken care of that needs to be done in order for the beneficiaries to now receive that property, then the clerk of the court would approve the distribution of the property to the heirs, and that would happen. Okay, a final accounting is done. I didn't mention that. A final accounting is done to the court. And once they look at those documents to ensure that you've done your accounting properly and they're satisfied, then you can distribute those final assets to the beneficiaries. Okay, let's stop. Let's take a break now. We've covered parts 1 and 2, the role of the professionals, what estate planning is, and the probate process, how estates are administered. We'll stop and pick up now with part 3, which would be the subject of wills.